right, welcome everybody to another edition of the Merging Minds podcast. Today our guest is Matthew Sag, professor of law in artificial intelligence, machine learning, and data science at Emory University School of Law. We have the privilege and honor to be with one of the foremost authorities in the field in the US. Matthew has already testified before Senate hearings and is someone who we can really learn a lot about when it comes to law and this new emergent field of generative AI. Matthew, thank you so much for making the time, being here with us. Really a pleasure.
Oh, Gabriel, thanks for having me.
And Matt, before we go into the technical richness of your work, can you tell us a little bit about your career and how you ended up doing what you're doing?
So my career is very non-linear. I started at college thinking that I was going to become an economist until I discovered that my handwriting was so bad I couldn't tell one Greek letter from another. And then I went to law school and I thought I was going to be a lawyer, and I was a lawyer for about 6 years in the technology field. And then I became a law professor. And I've always been interested in copyright and intellectual property and working in the tech sector, but really my focus in AI began before I really had a great understanding of how modern machine learning and AI worked. I was interested in the more just conceptual question of how should we think about uses of works that involve copying but don't actually communicate the substance of the work. And that's an issue that's been around since before AI, but it's now kind of the key issue in AI.
Right. And correct me if I'm wrong. I'm completely lay to all of your expertise. So and I think that's a good thing, because maybe I can help people understand better the level of complexity. So even if we take it before AI, am I correct to state that copyright isn't necessarily a black and white kind of issue? Is there a lot of gray area in copyright law without AI?
Yeah. There's definitely a lot of gray area in copyright law, and I think there are many areas of grayness, but the two most important ones are what is a copy? How similar does one thing have to be to another thing before we're going to call it a copy? And to give you some context, many years ago, like in the mid-1800s, the court said, oh, a translation's not a copy, it's a new work. Whereas, obviously it's both. And then the other big uncertainty is, well, what are the circumstances under which copying is justified?
Right. So even without AI, there is a lot of grayness, and that's why there are all these legal proceedings to try to determine where these things fall. But this really, from what I'm gathering, this kind of touches on the idea of the central concept behind copyright law, the idea of authorship, or are there other things that you would say are the main pillars? Is there like a cheat sheet that we can use to kind of define whether something is new or copied, or is this very subtle?
It's subtle in application. I think that really copyright revolves around original expression. And by original expression, I mean not just words that have not existed before, but words that reflect some kind of creativity or subjective authorial choice. And that is, that's really what copyright does. It protects authors for their original expression, but not their ideas or the facts or, methods. And it gives them the exclusive right to communicate that original expression to the public.
So to contextualize this, and let's say you write a paper, and I get your paper and I use the exact same structure and I just change some terms around, basically plagiarizing, that would be a very clear copy of your work. But go ahead.
Oh, probably, but it depends partly on how original my paper was. And there's a lot of plagiarism that's not copyright infringement.
Interesting.
Right? And those two concepts overlap sometimes, but not necessarily in either direction. So if I include long quotes from from Wikipedia in my work, right, it's for sure plagiarism, but it's not copyright infringement because, Wikipedia is on a Creative Commons license.
Interesting.
Or if I take your really original insight and idea and I include that in my essay, that could be plagiarism because I'm meant to acknowledge my sources, but it's not copyright infringement because copyright doesn't protect your original idea, no matter how great it is.
Interesting.
It just protects the expression of the idea.
That's very fascinating. I've never thought about it that way, but it makes a lot of sense. So when we're talking, and so it's not necessarily a function of, let's say, how much I deviate from the linguistical expression of your work, but it starts off with a question of whether the work was legally yours to begin with, right? At least from a legal perspective, that would be the central pillar, or am I wrong?
Yeah, no, that's more or less right. I mean, when copyright law was invented in 1709 in England under the Statute of Anne, they thought it was all about printing books. And but very quickly people began to realize, oh, we don't just want to give people the exclusive right to literally reproduce every word. We also want to protect people from kind of looser forms of appropriation. And so, you do have this kind of this hazy line between, okay, what is just idea, what is sort of generality, and what is expression. And that's just like you can explain the concept, but then applying it in practice is always a little bit murky.
Okay, so I think it's safe to say that we're already coming from a place of murkiness. And can you describe a little bit how much generative AI and all of this new tech adds to this murkiness?
Yeah, so I'm going to start out with the question of authorship. So when you write some words prompting an AI to do something, and it produces some text or an image or now a video that looks for all the world like a human might have made it, but in actual fact, it comes from the generative AI. It's really not clear that should get copyright at all. Like, to get copyright, the work that you create should reflect your individual mental conception. And the Copyright Office is really struggling with this question at the moment. People keep asking them to register things made on Midjourney, and the Copyright Office is like, we don't think that that's really authorship. But I think at some point people are involved enough. Their prompts are sophisticated enough. They're working in a kind of iterative or exploratory process. At some point, I think people are involved enough to be the author of what the AI produces, and ultimately, the AI is a tool, but it's, I think we're all struggling with how much human involvement and what kind of human involvement is enough to make you the author of, your ChatGPT text or your Midjourney image. So that's one fun issue. The other big issue is all of these generative AI tools were trained on copyrighted works scraped from the internet without any express authority. And, the question is that okay? Now, I happen to believe that by and large it is okay, so long as the things that the AI is creating don't look too similar to anything in the training data. I think that that's fine. I think that even though there is some technical, intermediate, and essentially invisible copying along the way, as long as the model hasn't just memorized the training data and the model is producing things that are genuinely new, I think that's exactly the kind of thing that copyright is meant to allow. But there's like a legal and a factual question there, right?
Got
The
it.
factual question is that really a good description? Are these models, are they not just copying the training data? And the jury's kind of out on that one. And then the legal question is, well, Matt Sag says that, but is he right? There are some cases I could point to with some analogous technologies that strongly suggest that I'm right. Some people are arguing at the moment, well, those cases are wrong. I don't think they're likely to be overturned, but they're arguing with perhaps a little bit more credibility. Oh, well, maybe generative AI is different. Maybe we shouldn't take the next logical step. And again, that's not my view, but it's not an insane view. So that's that's where we are.
So, if I'm understanding correctly, it's safe to break up the issue at least into two different issues. One is whether I can get copyright for work that I produced using some kind of generative AI. And the other question is, to what extent is generative AI in itself breaking copyright law by leveraging this content in its work?
Yeah.
So grossly speaking, it's like these are two different angles, let's say, to the same overarching problem. And I guess when it comes to, for instance, working with an engine like ChatGPT, is there a direct correlation, in your opinion, to the complexity of the prompt and the ability to copyright the response, or the number of iterations involved to produce a response? Or is that something that does not bear any weight on the actual content produced?
No, I think it bears a lot of weight. I think the standard that you're wanting to achieve is so that we can say, oh yeah, like that content that reflects your intellectual conception. And I don't think it matters whether your conception is like all at the beginning and you have like a really clear idea of what you're going for, or your conception is something that evolves over time as you interact with the system. I'm sympathetic to the Copyright Office because I think they were caught a little bit off guard by these developments and they're playing catch up. But I would be far less restrictive in terms of what I let people copyright. I mean, I think about if I use ChatGPT as a writing assistant, inevitably I paste that text back into a Word document and I change a whole bunch of things. I think that by the time I've changed some things and moved things around and edited it so it reads how I think it should read, I think I'm the copyright owner, not just of like the words that I've changed, but I think I'm the copyright owner of the whole thing, right? Because, it has my stamp of authorship on it. I think for people working in visual or video or sound, it's the same thing. Like you have to do more than just pull the lever on a slot machine or say, I'd like a cat on a surfboard in Central Park. Right? Yeah, you're not going to get copyright for that. But I think the tools are becoming more directable, like the visual tools, and people are becoming more sophisticated in their prompting strategies. So I think we're going to have to start recognizing that the people using these tools are the authors.
Interesting. And stemming from that, Matt, in your opinion, for instance, should there be legislation at some point to clearly highlight what has been human generated versus machine generated versus both? Or do you think this is a matter, it's going to become a very fluid state, or it should be a very fluid state? What are your thoughts on that?
Yeah, I don't think that we need that for copyright law reasons, but I think that we need it for a whole host of sort of consumer protection reasons. I think that people are going to be increasingly uncertain as to whether the images and videos and sounds that are being presented to them are real or synthetic. And, I fully support the idea that people have a right to know that kind of thing. But before we insist on labeling and watermarking, like we need to have a clear idea of what we're trying to achieve with that. If you've used an iPhone on portrait mode, well, congratulations, you're using artificial intelligence. And I don't think people want their iPhone photos watermarked in that respect. I think what people are really concerned about is authenticity, veracity, and it's important that we know whether these images are real or synthetic. I mean, and I think whether that means containing like an invisible watermark that can be detected by a machine or a little kind of AI stamp, that depends on the context.
Do you think it's more important, if you had to choose, do you think it's more important to differentiate between real and synthetic, or true or false?
I I don't know how we can. I mean, that seems like a really tough metaphysical question. Like what is a true photo? I mean,
Right.
It may not be.
I'm thinking more about the statements. Like, is this a true statement or a false statement, or a potentially misleading statement? I mean, obviously, there's a lot of grayness between true or false.
I mean, like if I think real and synthetic is the best we can hope for. I think,
Even if the synthetic becomes more accurate than the real.
I mean, then people will stop caring about the fact that it's synthetic. I just, yeah, I mean, labeling things as true and false is, I mean, we should probably do it more often, but it's really fraught.
Yeah.
Yeah.
Interesting. And Matt, is it okay for me to share my screen with you? I want to show
Yeah,
you
sure.
something and would love to get your thoughts on it from an authorship kind of perspective. Let me show you. All right. Can you see my screen?
Yeah, I'm just going to maximize. Hang on. Mm-hmm.
Okay. So this is our translation tool. It's called BureauWorks, and it's integrated with GPT if a user decides to do so. And in this context, what's happening here is that the green stuff is what we call translation memory. So that's part of the knowledge base. That means it's been done in the past and confirmed by a human. The blue is machine generated, Google. In this case, could be another machine translation engine. For this purpose, it's Google. And then the glossary is terminology that has been either self-extracted, which are the learned terms, again, machine generated, versus me teaching it you as vous here in French, which would be the formal version of you. That was taught by me. Now, let's say, for instance, I were just to confirm this segment. Does that make it mine if I don't change anything that's coming from this amalgamation of human and machine generated knowledge, or do I have to change something from an authorship perspective to make it mine, in your opinion?
Oh, that's a really good question. I don't think that the simple act of clicking, yes, I approve of that translation, is enough to make you the author of that individual translated sentence. But I think that a longer document composed of sentences that you've accepted and rejected using your own skill and judgment as a translator, you would be the author.
Interesting. So the sheer act of confirming this segment maybe doesn't make me the author of the segment, but if I'm over the course of 100 of these, rejecting a few, confirming most, I could maybe be considered the author of the word.
I think so. I think so. Because honestly, our threshold for authorship is not very high. I mean, we generally think of most photographers as authors of the photos they take, even though, cameras are so amazing these days. You don't really need to do that much. But I think, like the essence, like if you're looking at something that's simply the product of an algorithm, or that is simply correct or incorrect, or just performs a function, or is just a fact, right? That is not the basis of authorship. Authorship is about subjectivity and an exercise of your skill and judgment and,
Interesting.
And so, I think I don't think, I'm pretty confident that you're not the author of that single translated sentence. But, there's not a lot of value in individual sentences, most
right
anyway. But I think, you layer up those choices, and I think you're the author of that translation. Now,
just to go on a tangent here, like if I see this glossary mismatch warning and I realize that there's a mismatch between you and I'm using te here instead of vous, and I fix this. It's a very technical fix. If I'm understanding correctly, in your understanding, that still doesn't make me the author because there's no real subjectivity involved, or am I incorrect?
No. Like if there's no, if 100 translators are all going to agree that this is just the, absolutely objectively correct thing, then no, making that correction doesn't, it's the same as if you corrected a spelling error.
Got it.
It's things that are subjective, and they don't need to be unique. They don't need to be, oh, you're the only translator who thinks that actually, this is the best way to preserve the meaning and the cadence and the context. It just needs to be, you've made that choice.
It's very fascinating to me, man. I love the insight on the difference between the individual sentence and the document. That's really, I hadn't thought about it that way ever. And I think one thing that I do think is has always kind of already freaked translators out over the last few decades, but I think now is peaking, is we went from handwriting to typing, but for the most part, it was clearly, as you described, coming from an individual. Now, regardless of, let's say, how that plays as far as copyright law, at least it was clearly established that it was an individual transferring their own cognitive skills onto some form of medium. And then when machine translation kind of entered the arena, machine translation was so often grotesquely incorrect that it still, I would say, in many ways highlighted the sophistication of the human intellectual prowess. But now we have something that in its current state is already in much more evolved than previous versions of machine translation. And it really scares translators as far as, well, what's my role in all of this? And I'm just curious to see how you, from someone who's outside this space, how do you see this dilemma and where things may be potentially heading?
Yeah, so I spend a lot of time thinking about like not just this technology, but technology in general and like the adoption of technology. And I mean, most technologies change how we work, and some of those changes create employment opportunities and like sometimes even new industries, and sometimes they really present challenges for people who used to do something that was quite skillful and artisanal. And, it's the old sort of story of competing with mass production. I think, like 5 years ago, if we'd had this conversation, I would have been saying, oh, I think translators will be fine. This is just, it's going to make them much more, we're already seeing stories about machine translation making translators much more productive. And when you make an industry more productive, it doesn't necessarily mean that people lose their jobs. It means that you can do more translating. But the large language models are really, really quite incredible. I mean, I was in Japan 10 years ago using Google Translate, and it was hilarious. I mean, I know this because Japanese people kept laughing at me. And, my understanding is now it's a lot better. But the sort of, I would be surprised if at the moment we still didn't need like actual human translators with like linguistic and cultural competence and all of those things. But I think for people who just need kind of like a quick and dirty, what's the sense of this? I think that's something you can go to an LLM for. I don't know. I think like I'm not going to tell you shouldn't be worried. But it is kind of, I mean, I guess my question is for you, like you're using these tools and seeing what they can do. Like, is there really still like a significant gap between machine translation and an actual translator?
That's a great question. I think the way I see it, without context, yes, there will be a big gap. As you add more context, the gap begins to tighten, which is kind of the premise behind our tool, which is, yes, we leverage GPT-4, for instance, as a context aggregator, but we understand that, for instance, maybe one company talks about their homepage as the main page as opposed to the homepage, and uses different words for the same things, for instance. Different tonalities, different discourses. But in my opinion, we're already capable of mapping out that context more granularly than ever. When you feed it to a large language model, it's capable of making connections that are way deeper than the connections previously done. So I think the way I see it, there's still a lot of room for human translators to become gatekeepers of this context, but not necessarily to perform the linguistic grunt work. So just like in the example where you described, right? If they're making that same change that maybe 100 or 1,000 other translators would perform exactly the same, if there's no subjectivity involved, then my bet would be that work will be largely taken care of. But when it comes to becoming the guardian of a context, I think that still has room for a lot more sophistication than where we're currently working in. So that would be my guess. So I'm not particularly worried, let's say, about the livelihood of a given translator, provided that they're willing to work with the technology. But I do see a lot of threat for people who still want to continue to do things the same, using the analogy that you talked about photography, right? If you were an artist doing realist paintings and photography is all of a sudden introduced, either you adapt and you start to produce paintings that are more original, more authentic, more imaginative, and your authorship and the worth of your work increases, or you start to compete with something that is mechanically better than you can be, and faster and cheaper, and that's not likely to be a win for the person who tries to do that. So that's kind of my perspective, but I would love to hear how you see that.
Yeah, I mean, I think about photography a lot in this context because photography changed art. Like, it changed the way we think about art. It changed originally some people thought photography, well, that's just mechanical. There's nothing artistic in there. And they also
Right.
thought it was like truth. And I think now we don't think either of those things. But by the same token, no one really wanted their portrait painted very much after we could do that with cameras with much less time and greater fidelity. And artists, I think that's when art started becoming a lot more abstract. Right? So it changed art, not just in a sort of competitive niche sense, but it changed the way artists thought of art, what we should value in art, and how we should be expressing that value. And I think, like, when I think about large language models, I think they're going to change the way we think about writing. I think we're going to value writing that is not just competent. We're going to value writing where it's persuasive and makes sense, but each word isn't necessarily predictable based on the previous word.
Right.
Like, if you think about the way a language model works, it's predicting one token, essentially one word at a time. And there's very little surprising once it starts a particular output. Whereas I think some of the best writing really is surprising. Like, not in every single word or sentence, but at least within a paragraph or within a few paragraphs, there's something that's like, oh, I wasn't expecting that. Where's that taking us, and how's that leading us back? So I think we're going to see, like, the bar on writing has just been raised. Like, everyone expects minimum competence now.
Mm-hmm.
Just the same as spell check. It's like, everyone expects, spelling error-free documentation all the time, and they should. And I'm a terrible speller, but I use spell check all the time. And, that's just what you do. I think, so what we value about writing, I think, is actually going to change now that just basic competent writing is something that, a computer can do.
It's very interesting you mentioned that. I had a conversation last week with professor of comparative literature at Emory College called Catherine Elkins. And she was talking about this human characteristic, which she labeled as burstiness, which is this ability to almost unpredictably occasionally depart from that standard discourse that's being used. And I think that's interesting what you described, whereas even if you elevate the temperature of a generational model, it's going to be like more awkward and random throughout. It's not going to necessarily be bursty. And I love that word, just because it really is like, it's like this, there's this characteristic of popping, but every so often, similar kind of like to abstract art, in the sense that it's, it's not entirely necessarily crazy, but there's some things that make you rethink. There are these bursts that make you rethink how you see things.
Yeah. No, I think I like that word as well. And I made a note. I'm gonna look the person up. I think this is really, I mean, if you think about if you think about like things we think of as like important changes in science and art, maybe some of them were incremental, but a lot of them were actually going against the flow. Like they weren't just the logical extrapolation of data points that had come before. They were looking at what had come before and being different. And I think, I think we've always valued that in terms of creativity, but I think we're going to value it more consciously.
Yeah.
Because computers are going to give us this sort of obvious extrapolations on all sorts of things.
It's very interesting. It's like it's already changed the way I see my writing. I mean, I used to try to iron out my quirks in my drafting process. And now I get suggestions sometimes from Grammarly or any tool I'm using to make things more standardized. And unless it's a clear error, I tend to reject those, even though I'm not expressing things maybe in the most sound way from a grammar perspective. It's mine. It feels, and I can value that uniqueness more.
Yeah. But I also think, I think that's right. I mean, like these tools are incredibly helpful to alert you to when you're departing from the convention and the status quo. But I do worry about the sort of the reductive nature of getting us all to write in exactly the same way. I mean, sometimes I want to split an infinitive, right? Sometimes this sentence needs to be long and then the next one is short. And that is, I hope people continue writing like individuals.
So, and just tying this back again to translation. So if based on what I understood at the beginning of our conversation around copyright, even without technology, let's say the first thing that needs to be clear, I guess, in the translation is if a work is copyrighted, first I need permission to translate that work. Otherwise, I'm breaking copyright, correct?
Yes.
Okay. So assuming I have permission, my translation, even though I were to work with my own handwriting, my translation, if I'm understanding correctly, wouldn't be copyrightable, or would it be copyrightable?
Oh no, it absolutely would.
As an individual work.
As a new work, yeah. If you translate something that is not copyrighted, either because it's in the public domain because it's a US government work, or it's just old, or you translate something where you have permission to create a translation, your translation operates in this weird duality of it's recognized both as kind of a copy, but also definitely its own original work.
Interesting. And if I were to grant legally the copyright to the original owner of the work in the original language, that's something that from a legal perspective I could do.
Oh yeah.
But then now taking it to the, let's say, the more machine hybrid process that I was illustrating earlier. Now, let's say I translate a book using that process. If I understood correctly, as long as in the overall work, maybe I'm not the owner of an individual sentence because I just confirmed it, but as long as I can prove that there is a degree of subjectivity in some sentences being rejected and others being confirmed, I could still be considered the owner of that copyright. Is that a correct assumption?
Yep, I think that is 100% correct.
That's super interesting because that's where I think it's super cool to separate the idea of copyright and authorship, because in my mind, it's all kind of mixed up. And I probably would feel a lot more the author of something that I hand wrote from scratch because there's this visceral component to it because I'm writing every single word than I would using our technology, for instance. But technically, from a copyright perspective, it wouldn't be that different, right?
In most practical ways, it really wouldn't be that different. Because ultimately, how are you going to exploit your copyright? You're going to exploit it by exercising a veto over, the reproduction of the work in total, or actually probably just licensing someone so that they can reproduce the work in total. And to that extent, like whether you have like just enough copyright or like a lot of copyright doesn't really make a difference. It could make a difference in some kind of weird infringement action. Like, let's say, I quote without permission, or really without a good reason, like 10 paragraphs of your translation without your permission, and you sue me for copyright infringement. Like, I could plausibly say, look, there's copyright in the whole book, maybe, but there's not enough in these paragraphs. Whereas
Interesting.
if you'd done the translation by hand, then that'd be a pretty poor argument. But realistically, that's not where you're going to get the economic value from your translation, is like suing bloggers who quote things. Like, the economic value comes from, there's now a French edition or a Lithuanian edition of this book available on Amazon that wasn't before. So I think there is still copyright in your translation.
That's very interesting to think about. And in your opinion, Matt, how does, I mean, the law tends to be, from my understanding, tries to be as clear cut as possible about things with certain definitions, such as individual versus non-individual and things like that. But when you take, let's say, a more avant-garde or post-structuralist approach to what an individual is, and you go to start getting into more academic deconstructionism and things like that, and challenging the idea of an individual mind and talking more about the communal nature of language and so on, how does the law see these things? Does it take a more structuralist approach? Is it able to contemplate these nuances? I'm just really curious.
Yeah. So the law, I mean, particularly copyright law, is quite unpostmodern in a lot of the ways that it thinks about authorship. Occasionally, it's postmodern in the way that it thinks about infringement and what's a justification for copying. There's a lot of latitude for parody or even pastiche. But one of the things that copyright actually does a lot of is it really simplifies complicated questions of authorship and attribution. So we have all these doctrines in copyright that are really designed pragmatically not to leave us with too many authors, which is kind of perpetuating the myth of the author as the sole genius. I mean, think of a book, right? We think of Danielle Steele as the author of her books. We don't think of her publishing house and her editor, who play a substantial role, as constituents of that authorship process. But in reality, they probably are to some extent.
It's interesting to bring up that example, because I was talking with my wife earlier this week. She wrote, I think, 180 books over the course of her lifetime. And I was just thinking, how is that humanly possible?
It's astonishing. So I come to that example because I'm just reading a book called Big Fiction by an Emory professor, Dan Sinekin, which is all about publishing conglomerates and how they've changed literature. And there's a lot of Danielle Steele in there. It's remarkable. But yes, I think think about a movie, like, when we think about the author of a movie, we think, Spike Lee, he's the director. And we kind of, we sort of focus on one creative mastermind, and we say, everyone else is just kind of assisting him and making contributions. And some people critique that. I mean, it's a very unpostmodern way to think about it, but it's a way of thinking about authorship that pragmatically works for copyright law, because copyright is meant to create incentives, and you need some. It's just easier if you can say, look, we just need to talk to this Spike Lee guy. We don't need to talk to the set designer. We don't need to talk to the cinematographer. So even though I think we should think critically about authorship and influence, and no one is truly an individual, for the purposes of copyright law, and probably in patent law as well, like it's pragmatic to just be a little less postmodern and say, who's the main person? Like, who really had control? Like, whose stamp is all over this?
What about ghostwriting? Like, let's say I publish a book with a ghostwriter, but I'm giving them, my ideas, my feedback. From a copyright law perspective, how does that typically play?
Yeah. So I wrote an exam question on that theme a couple of years ago, and the answer is it depends. I think in what I think of as the standard ghostwriting situation, the ghostwriter is the author and they're the only author. But if the subject of the book tells the story in a particular way that is in fact very closely reflected in the ghostwritten version, then you could make a strong argument that they're a co-author. If they maintain and exercise ability to basically final copy, and they actually, make changes or require changes be made, that would strengthen their claim to be a joint author. The joint authorship cases are really interesting, and they're all like very kind of fact intensive. But it's interesting. Like, we would like to think that we own the story of our lives, but we really don't. And and what's copyrightable is the way that story is expressed.
Interesting.
And that's why when you hire a ghostwriter, you should have a good contract with them.
That's fascinating. It's so you mean translating into my own life, for instance, the uniqueness of my life story carries no property, but the expression of it does. So that's I mean, maybe that's simple for a lot of our viewers, but for me that's mind-boggling, because I know that that's not the instinctive way that I approach it. I think of my life story as mine.
Many people do, and so when occasionally people get sued for making documentaries, people are like, "Yeah, you didn't buy my life rights," and like, life rights are pretty much like not a thing.
Interesting.
What people are really doing when they sign those contracts is they're buying peace and the right not to be sued for defamation. But think about how biography would work if public figures could stop other people telling their stories. I mean,
Interesting.
that would not be good. But yeah, it's like I like to think that some of my work is interesting, but I'm pretty confident that no one wants to tell the story of my life anyway, so it doesn't really trouble me.
And I don't know if you're very familiar. I imagine you must be familiar with the case, but I'm very I know it very superficially. But do you have an opinion on the New York Times versus OpenAI case, and how do you think that could potentially change things moving forward?
When I first looked at the complaint and I looked at the exhibits, I was really quite shocked at the extent of memorization that they were able to show. And it really shook one of the sort of factual assumptions that I had made based on everything that I understand about how these models work and that they're trained. I was like, there's no way there should be this much memorization. Then I looked again more carefully, and I think most of their examples are actually not from, the model has memorized their articles as training data, but actually they asked the model as an agent, hey, go out on the internet and find this and report it back to us. And that's still a copyright problem, because, the model shouldn't be serving up New York Times content to people who aren't paying their New York Times subscription. But it's actually like a really small and easily solved copyright problem. Like, the big problem would be if, when OpenAI trained their model on like a lot of New York Times content, but still like a drop in the ocean, we're talking hundreds of millions of documents would have gone into this. If that process just inherently ends up making a copy of a lot of the training data, then the argument that that's fair use becomes quite difficult to sustain. So that was my initial reaction. But when I looked at it more carefully, I realized, oh no, I think actually all of their really compelling examples are not because of that. It's because their model can now go out onto the internet and find things and then do a little synthesis of what it's retrieved. And it wasn't really doing a synthesis, it was just copying it verbatim. And like, just in terms of damages, it's like, well, every time they can show that happened, they will get like statutory damages for that article, but that's not going to cost OpenAI very much money. The real disaster for OpenAI would be if someone was able to show, this model, it isn't just learning at an abstract level. It's basically just Napster. like it's just a jukebox. It's just like a really expensive jukebox, or at least substantially that's what it is. If that turns out to be the case, then yeah, that's not right. Like they shouldn't do it that way. As you can imagine, I get asked to comment on these kind of cases quite a lot. And the thing I always have to say is don't be too impatient for resolution of these cases, because I don't think they'll be quick. And I think, you can file a court case saying almost anything. We won't really have a good sense of like what are the true facts until this case goes through the process of discovery and then probably motions for summary judgment, and then we'll have a better idea of like what's real and what's not. So I don't, I'm not saying the New York Times doesn't have a good case, because I don't know, I really don't know the facts well enough to say that. I don't think they know the facts well enough to say that either. I think maybe OpenAI knows the facts, but we are going to have to wait and see.
Interesting. So you mentioned that the translation is both a copy and the original at the same time. What about the synthesis of text into a reduced version? Is that also a copy and the original at the same time, or is that something different?
It's like, it depends on the degree of synthesis. And you can think about it as like computationally, you think about it as like an information reduction question. But like, just to give you like a prosaic example, like there's a novel called The Old Man and the Sea, right? There's a Wikipedia entry on The Old Man and the Sea. It tells you a lot about it, including like a plot summary. I don't think that the Wikipedia entry infringes the copyright, right? Even though, I think it's more information about the work rather than conveying the original expression of the work. But there's also a illustrated children's book called The Kinder Guide to the Old Man and the Sea, and that retells the same story to be enjoyed as a story, and it's much more simple, but it has all of the highlights, and that is definitely an infringing copy of Old Man and the Sea, even though like if you read the kids version, you're missing out on a lot. And so at some point, like you've done enough kind of synthesis and abstraction that copyright law says, yeah, you're good now. Like maybe norms of plagiarism are different, right? Like I would be plagiarizing Old Man and the Sea by simply proposing a novel, with that plot and that theme, and without acknowledging, oh yeah, actually someone's already written that novel. But in terms of copyright law, like it really is about, are you communicating their original expression in some form to a new audience, or are you just providing information and analysis of their original expression? Or are you like using their work as a springboard, but actually your work is quite different and you layered so much on top that you can not really even see their work underneath? Like, then that's also not a copy. But, these like drawing those lines can be very difficult.
Very interesting. Well, Matt, I really appreciate your time. I've learned so much. My head is very packed with information that I need to digest. I've realized a lot of my premises around copyright and authorship were completely wrong. So yeah, I love when that happens. It means that I have a lot to learn. And would just like to wonder, I hear that you're hosting a third annual Legal Scholars Roundtable on artificial intelligence. Would you like to talk a little bit about that?
Oh, yeah, sure. So I think one of the most important things you can do as an academic is build up communities, and particularly for like a new field where there's, it's really like people coming together from all sorts of disciplines and parts of law and computer science to try and think about, how should we think about these legal issues? It's just really important to get everyone in the room. So my friend Charlotte Scheider and I, we started this conference, I guess, 3 years ago, just as a roundtable to bring in legal academics together, exchange papers, comment on papers, etc. By the time this podcast goes out, it'll be too late for people to apply to attend. We're very proud of it. We think it's great. And, this is the third annual. There'll be a fourth annual next year.
Very, very cool. And Matt, if anybody in our audience wants to reach out to you to learn more or consult with you, is there any best channel for people to reach you?
Oh yeah. My email is very easy to find on the internet. There aren't that many Matthew Sags out there. But yeah, I'm just msag@emory.edu. Yeah.
Very cool. Well, Matt, it's been an honor, a privilege. Really, I learned a lot still, and also realized how much I have left to learn, which is infinity. But really appreciate all of your insights, all of your knowledge, your candor, your patience with me. And thank you so much for your participation, and look forward to hearing more about your works and publications. We'll keep in touch.
Yeah, no, thank you. I've really, I so thoroughly enjoyed this. This was so interesting. And I honestly have only ever thought like a little bit about translation. And this was really, really interesting. Can I just tell you, I don't know if this would be of any interest to you at the moment, but I'm reading a book called Babel, which is sort of like a science fiction book, but it's essentially all about translators. It's all about translators who can perform magic by finding words that in some way have identical meanings. So, like the Chinese word and the English word, but also there's something missing from that meaning, and they're therefore able to harness like what's missing in the middle. And, it's a fun story, but it's also like, I'm not aware of many other books that are all about translators.
That's wonderful. I'll check it out. I mean, that sounds right up our alley.
Yeah.
All right. Well, thank you so much, Matt, and really look forward to more opportunities to learning more with you. Thank you, everybody, for watching. It's been great.
Thank you. Bye.